National Symposium on the Law of the Sea and the West Philippine Sea.
And is one of the most significant and visionary international instruments of our time.
At a time when the Philippines continues to face serious challenges in its maritime domain, this gathering serves as a critical national purpose to strengthen public understanding, sharpen legal clarity, and build a broader national consensus on the defense of our maritime rights and interests.
Hopefully that will then enable us to appreciate and understand why the law of the sea is not only a very important and essential aspect of our foreign policy, but also an important part of our domestic law and policy.
States still have to operate under, principles of restraint, not, non-aggression, non-abuse of rights, still showing due regard.
Aside from explicit violation of the arbitral tribunal or non-recognition of the arbitral tribunal, they're very, very adamant in their claim that that portion of the South China Sea is theirs. So,
in light of persistent actions by China that appear sea regimes, how should coastal states like the Philippines respond?
And for a country like ours, I think it's important for us to be able to hang on to that, and at the same time work for an international community that works on the basis of the rule of law.
Almost every country in our part of the world is grappling with the same question. How do we deal with China? Pero alam natin na hindi dahil lawyer ay alam na ang issue sa West Philippine Sea. Kahit nga lawyer na at senador ka pa, pwede ring hindi talaga alam ang issue ng West Philippine Sea.
This map is the last official map of Philippine territory during the Spanish regime. It is the most complete and most detailed map of Philippine territory.
Of course, we know that China did not participate in the case, regards the award of the tribunal as null and void and not binding on China. In every corner of Luzon, Visayas, and Mindanao, there must be an informed legal professional. Indeed, an informed Filipino, ready and able to explain the truth, debunk disinformation, and stand firmly on the side of international law and our national interests. In that sense, all of you here tonight are part of that mission. And for that, the Philippine Coast Guard, on behalf of the Commandant, thank all of you.
This is exactly where the trouble is being caused, and it all goes back to the map of non-existent islands drawn in 1936.
Yesterday, I think today, the Chinese embassy said that we cannot claim the spot list because we did not exercise continuous and peaceful display of sovereignty.
To the truth, to the law of the sea, to the Filipino nation, and to the enduring defense of our maritime rights. Cheers!
Good morning, everyone, and welcome to the second day of the National Symposium on the Law of the Sea and the West Philippine Sea. We will now begin with session 5. May we request on stage Dr. Christian Schultheis to give us a lecture. A round of applause, please.
All right, good morning. I'd like to start by thanking the organizers for the kind invitation to speak here today, and all of you for your interest in my lecture. Coming from Heidelberg, I thought I could not possibly begin without a reference to José Rizal, who lived and studied in Heidelberg, not too far from the Max Planck Institute, and who gave us the wonderful poem, To the Flowers of Heidelberg. Now, whether I can bring flowers today from Heidelberg, I'm not so sure. The dispute settlement system of the UN Convention on the Law of the Sea is complex. Perhaps my lecture will be a little bit dry, like flowers in German winter. So my apologies, I won't be able to show you a lot of nice images. But as we all know, no reward without effort. And the reward of the dispute settlement system of UNCLOS is to have results such as the South China Sea arbitration. 10 years ago, an arbitral tribunal established under the UN Convention on the Law of the Sea rendered its award on the South China Sea. China rejected the tribunal's jurisdiction and its finding and has continued to assert claims that contravene the award. Disputes between the Philippines and China are not settled. Clashes have intensified, and China regularly calls the award null and void. There can be no better time to discuss dispute settlement in UNCLOS. Generally, international disputes are central causes for conflict. The availability of options for the peaceful settlement of disputes is therefore a key aspect of international law and treaties. Dispute settlement is essential condition of tribunals, essential contribution of tribunals to peace and security. But in the case of the South China Sea, the very means by which disputes ought to be resolved are contested. This lecture will therefore introduce the dispute settlement procedures of UNCLOS. Its starting point is the principle of consent. States are not subject to the jurisdiction of international tribunals absent consent. The basic idea of consent to the jurisdiction of tribunals is that jurisdiction only exists within the limit within which it has been accepted. An important function of dispute settlement clauses in treaties, therefore, is to indicate whether such consent is granted, with respect to which type of disputes, and before which tribunals. This lecture will address these 3 points with regard to UNCLOS. It will illustrate how the idea of consent to jurisdiction operates in the dispute settlement procedures of the Convention. So this lecture is not a commentary of the South China Sea arbitration. However, I will occasionally refer to the arbitral award and China's critique. This is done to not discuss the procedures only in the abstract. I hope that at the end of the lecture, you have gained an understanding of the functioning of the dispute settlement system and how the idea of consent operates in it. So here a brief overview of my lecture. I begin with some core elements of dispute settlement in UNCLOS. I will then discuss part 15 of UNCLOS, so this is the longest part of my lecture. And then part 3 and 4 will raise the question of what happens after an arbitral tribunal rendered its award. This will clarify the question of what it means for a decision to be binding, and here I will briefly introduce as well the topic of compliance. Briefly, because the panel discussion after my lecture will be devoted to this topic. And of course, if you would like to hear more about the South China Sea arbitration, then we have the Q&A as well. So let's start with the core elements of dispute settlement under the Convention. Consent, the balance between voluntary and compulsory means, and the purpose of the dispute settlement procedures. So the basic idea of consent to the jurisdiction of tribunals is that jurisdiction only exists within the limits within which it has been accepted. States give consent to binding dispute settlement procedures in 2 ways. First, by special agreement, and second, in advance, by becoming a party to a convention that contains such dispute settlement procedures. Therefore, understanding the dispute settlement system of UNCLOS entails grasping the types of disputes and procedures by which a state party has consented to be bound in advance. This is somewhat complex, as UNCLOS has one of the most elaborate dispute settlement systems in any convention, and as well because the type of dispute strongly affects the means of dispute settlement that are available. It is also important to note from the beginning that UNCLOS does not permit reservations under Article 309. So therefore, by becoming a member of the Law of the Sea Convention, a party consents to the dispute settlement system in its entirety. Building on the principle of consent, UNCLOS establishes what may be called a 2-tier system, so voluntary and compulsory procedures. UNCLOS thus combines two approaches, namely the free choice of means of dispute settlement on the one hand, and the need for compulsory procedures on the other. The convention creates a balance between the free choice of means and compulsory procedures. So we can see this balance in part 15, which is devoted to dispute settlement. This part has three sections. Section 1 contains general provisions and voluntary dispute settlement procedures. Section 2 sets out compulsory dispute settlement procedures, and Section 3 provides for limitations and exceptions to compulsory procedures. Generally, states must first try to settle disputes between them according to means of their own choice, but where no settlement has been reached by recourse to voluntary procedures under Section 1, that dispute must be settled according to compulsory procedures in Section 2. And then there are several annexes of UNCLOS that specify voluntary and compulsory procedures in more detail. There's Annex 5, which establishes the procedure for conciliation. Annex 6 contains the statute of the International Tribunal for the Law of the Sea. Annex 7 defines the procedures for arbitration, and Annex 8 deals with special arbitration. Some of these procedures enjoy growing use. So to date, states have relied on arbitral tribunals in 15 disputes. UNCLOS has registered 32 cases. Special arbitration under Annex 8 has not been used so far. Special arbitration is essentially about arbitration by technical experts in the field of fisheries, marine environmental protection and pollution and navigation, and as well marine scientific research. Compulsory conciliation has been used in one case, but it should also be noted that the ICJ sometimes hears law of the sea cases, for instance concerning a sea boundary delimitation, but so far these cases at the ICJ were not based on Part 15 of UNCLOS, but on the statute of the ICJ or a special agreement. One more general remark is about the purpose of dispute settlement procedures in UNCLOS. UNCLOS establishes a comprehensive international legal framework to govern activities in the ocean. So it contains a careful balance between rights and obligations of many different interests, so coastal states, user states, flag states. I guess you heard more of this in yesterday's lectures. So to preserve the balance of rights and obligation inside UNCLOS and to guard its compromises against unilateral claims, states parties put in place a compulsory dispute settlement system. We can say that by settling single disputes, tribunals not only contribute to preserve peace, but also to the stability of the legal system as a whole. So we are now in part 2 of my lecture. So let's take a closer look at section 1 of part 15. Section 1 is often described as being about voluntary procedures, even if the convention does not use this term. Section 1 begins with the obligation to settle disputes concerning the interpretation or application of this convention by peaceful means and with references to the UN Charter. So here the peaceful means are mentioned in Article 33 of the Charter, and these are negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. And Article 280 of UNCLOS also echoes the UN Charter by stressing that parties have autonomy to choose at any time the peaceful means of their own choice. Consequently, parties to a dispute may, by agreement, stop a procedure and have recourse to an alternative means of dispute settlement. Article 281 further elaborates on voluntary procedures. If the states parties which are parties to a dispute concerning interpretation or application of this convention have agreed to seek settlement of the dispute by peaceful means of their own choice, the procedures provided for in this part apply only where no settlement has been reached by recourse to such means, and the agreement between the parties does not exclude any further procedure. So, voluntary procedures take precedence over compulsory procedures, and this also raises an important question. Can states agree to exclude compulsory procedures under Part 15 by bilateral or regional agreement if a dispute, even if a dispute is not settled. So can they exclude compulsory procedures even if a dispute is not settled? The answer is yes, but only if the agreement does so in explicit wording. You can see the practical relevance of this provision immediately when you consider the ongoing negotiations on a code of conduct. In principle, in theory, it would be possible for a code of conduct to exclude compulsory procedures such as arbitration from dispute settlement in the South China Sea. My guess is that the current negotiators, Philippines perhaps, or other countries, will make sure that the code of conduct does not contain such an exclusion, but it is possible. So at this juncture, it is appropriate to examine one of China's arguments contesting the jurisdiction of the South China Sea arbitration. So in China's position paper of 2014, China argues that by signing the 2002 Declaration on Conduct, the Philippines and China have an obligation to settle disputes through negotiation, and they agreed to seek settlement of the dispute by peaceful means of their own choice within the meaning of Article 281. The tribunal, however, was not convinced that the DOC excludes compulsory procedures. Why not? First, the DOC is not a binding agreement as required by this article, and second, the DOC does not explicitly exclude compulsory procedures. Let us come back to the convention. Article 282 allows a party to a dispute to have the dispute settled in accordance with a procedure previously agreed if such procedures entails a binding decision. An example would be the optional clause under Article 36, paragraph 2 of the statute of the ICJ. So here it appears that between two states that both accepted the optional clause, the jurisdiction of the ICJ prevails over Part 15. Another example would be the MOX plant case of 2003. Here an arbitral tribunal suspended procedures on a dispute that also involves European Union law and the European Court of Justice. And here one of the arguments for this suspension was the mutual respect between courts. Note that in both examples, the key consideration is the existence of a binding procedure in lieu of the convention. Therefore, assuming even a strict exclusion of Part 15 under this article, the result cannot be the absence of a binding procedure. Article 283 sets out an obligation of the parties to exchange views concerning the settlement of the dispute by negotiation or other peaceful means prior to binding procedures. So this is not a formality. This article does not require that negotiations need to be exhausted prior to using binding procedures. So it is important to note that the ICJ has not accepted the notion that the UN Charter requires all diplomatic negotiations to be exhausted before adjudication can take place. Instead, this article requires parties to try and reach agreement on the approach or on the means they like to take to solving a dispute. So this requirement can be seen as an emphasis on the voluntary choice of procedures for dispute settlement. Article 284 provides for voluntary conciliation. Here, special or ad hoc consent of both parties is a prerequisite to the submission of a dispute to conciliation. And the conciliation procedure falls mainly in the voluntary category, as we can see in paragraph 3, but it adds substance, as you can see in paragraph 4. Once parties agreed to conciliation, they must go through it. Moreover, there are a limited number of disputes that may be submitted to compulsory conciliation. So we will now deal with section 2 of part 15, compulsory proceedings entailing binding decisions. The provision that links voluntary procedures under section 1 and compulsory procedures under section 2 is Article 286. Any dispute shall, where no settlement has been reached by recourse to section 1, be submitted at the request of any party to the dispute to the court or tribunal having jurisdiction under this section. So the keywords establishing advance consent to the jurisdiction and kind of dispensing with any need for additional or ad hoc consent of the respondent are at the request of any party to the dispute. So before moving on with this section, I'd like to quickly reflect on the words voluntary and compulsory procedures, as these sometimes invite confusion. The term voluntary dispute settlement procedure is not used in UNCLOS, but it is often used in legal scholarship to summarize procedures in section 1. As we can see in Article 286, the existence of voluntary dispute settlement procedures does not exclude compulsory procedures. In UNCLOS, there are voluntary procedures and compulsory procedures. Voluntary procedures under Section 1 take precedence over compulsory procedures under Section 2. But where the means chosen voluntarily by both parties cannot settle a dispute, a party to a dispute may choose to submit a dispute to arbitration or a court. Moreover, we have seen that voluntary procedures can include binding procedures, as in Article 282. So the compulsory character of the procedures has several consequences. First, the court or tribunal to which a dispute is submitted itself determines whether it has jurisdiction. So this is Article 288, paragraph 4. In the event of a dispute as to whether a court or tribunal has jurisdiction, the matter shall be settled by decision of that court or tribunal. Second, under Article 290, a court or tribunal can order legally binding provisional measures to prevent the respective rights of the parties to the dispute, or to preserve the respective rights, or to prevent serious harm to the marine environment. And third, a decision by a court or tribunal is final and binding, pursuant to Article 296. Absence of a party or failure of a party to defend a case is not a bar to the proceedings. And I will come back to this point. It is also important to note paragraph 2, any such decision shall have no binding force except between the parties and in respect of that particular case. So there is no binding force of the South China Sea arbitration between China and Vietnam or between China and Japan. So again, reflecting the idea that states should be able to choose their preferred forum for compulsory settlement, Article 287 allows states to choose between UNCLOS, the ICJ, arbitration under Annex 7 or arbitration under Annex 8 for certain disputes. However, if no declaration is made, or if two states did not choose the same forum, Annex 7 arbitration is the default forum for compulsory procedures. It should be added that the court or tribunal that has jurisdiction is required to apply the convention and other rules not incompatible with the convention. This includes rules concerning, for instance, the law of treaties, but the convention also incorporates law of the sea rules other than the rules that are explicitly specified in the convention. So, for instance, the arbitral tribunal in the South China Sea considered that the convention incorporates the rules of the Convention on the International Regulations for Preventing Collisions at Sea. So let's now move on with limitations and exceptions. So we are now in section 3 of part 15 of the Law of Sea Convention. Section 3 contains limitations and exceptions to the jurisdiction that the court or tribunal may exercise with respect to disputes concerning the interpretation of the convention. Among these provisions, Article 297 sets out limitations that apply automatically to any dispute, and Article 298 then contains further optional exceptions that the state party may activate by declaration. Article 297, paragraph 2 and 3 provide for the application of compulsory dispute settlement procedures to marine scientific research and fisheries, but the paragraph exempt a coastal state from the obligation of submitting to such procedures any dispute relating to fisheries in the coastal states EEZ or certain issues regarding marine scientific research. So there is no compulsory dispute settlement for EEZ disputes regarding what is sometimes called the discretionary powers of a coastal state over fishing and marine scientific research. Article 298 enumerates specific optional exceptions to compulsory jurisdiction, and states may exclude these types of disputes by a written declaration. So these are first disputes concerning the interpretation of Articles 15, 74 and Article 3 relating to sea boundary delimitation or those involving historic base or titles, disputes concerning military activities, and disputes concerning law enforcement activities by a coastal state with respect to fisheries and marine scientific areas. It is noteworthy that the exclusion of disputes over sovereignty or islands is only explicitly mentioned in Article 298, paragraph 1.a1 in the context of compulsory conciliation. The reason for this is that sovereignty questions are not addressed by the Convention and therefore not part of the jurisdiction of UNCLOS tribunals. While the ICJ has settled disputes where boundary and territorial issues are mixed, the source of jurisdiction for these cases is not the Convention. So at this point, it is good to look again at the South China Sea arbitration. This is because the optional exceptions to compulsory jurisdiction have been at the heart of the award and of China's criticism. China made a declaration under Article 298, paragraph 1, and therefore excluded sea boundary delimitation from compulsory jurisdiction. It may very well be that China believed that this declaration would exclude all issues with an impact on boundary delimitation from compulsory jurisdiction. The Philippines, however, presented the dispute as a dispute over the source and existence of maritime entitlements, and it insisted that questions of maritime rights and boundary delimitation are different. They are different, even if a decision on the absence of entitlement has very important consequences for sea boundary delimitation, namely no sea boundary delimitation is required. So the optional exclusion of boundary delimitation from a tribunal's jurisdiction does therefore not exclude a tribunal from deciding a case on the existence of entitlements. So how are we to look at the jurisdictional separability of entitlement and delimitation? The first point to note is that the substantive distinction between entitlement and delimitation is well established in the law of the sea. The ICJ had already argued in the North Sea continental shelf case in 1969 that the basic concepts of continental shelf entitlement is essentially one of drawing a boundary line between areas which already appertain to one or the other of the states affected. So it's very easy to reformulate the South China Sea arbitration using the language of the North Sea continental shelf case. Namely, the tribunal established that claimed maritime zones that exceeds the rights under UNCLOS cannot already appertain to China. And if some maritime zones do not already appertain to China, then the process of delimitation is not required. And if the process of delimitation is not required, the jurisdictional exclusion of boundary disputes does not bar the tribunal's jurisdiction on questions of entitlements. Here we could note that the Chinese lawyers accepted this distinction between entitlement and delimitation in one of their publications, their long analysis of the South China Sea arbitration in the Chinese Journal of International Law. The second point is the rejection of the idea that the jurisdictional exclusion of one aspect implies the exclusion of another by virtue of two aspects being connected, even if this connection is closed. So the ICJ rejected the idea of an implied jurisdictional exclusion. And in the South China Sea, we can say this rejection is reinforced by the fact that if an exclusion of determining entitlements were implied by the jurisdictional exclusion of delimitation, then that which precedes the process of delimitation as a matter of substantive law, namely the question of the existence of entitlements, would be excluded from jurisdiction by virtue of the posterior issue being excluded. We can discuss that perhaps further in the Q&A. So that brings me to the next topic, the binding nature of the award. What happens after a duly authorized, duly constituted arbitral tribunal rendered its award? Now, given China's persistent refusal to accept the arbitration, the question arises what it means for an award to be binding. As noted above, Article 296 provides for the finality and binding force of decisions. Any decision rendered by a court or tribunal having jurisdiction under this section shall be final and shall be complied with by all the parties to the dispute. Thus, an award rendered by a tribunal is final and binding on the parties. No difference is to be made between UNCLOS and Annex 7 tribunals, so long as they have jurisdiction to hear the case. Awards of Annex 7 tribunals are no less binding than decisions of UNCLOS. They are equally binding. The bindingness is further confirmed when looking at the International Court of Justice. The ICJ explained the binding nature of decisions in the following way. Decisions of the court, whether on jurisdiction or on the merits, are final in the sense that they cannot be reopened by the parties as regards the issues that have been determined. So this was in the application of the Genocide Convention case in 2007. So here we can relate the question of the bindingness of an award back to the starting point of this lecture, namely consent and free choice of means to resolve disputes. Under international law, states are free to select a means to resolve their disputes. However, once a state has consented to the jurisdiction of an international dispute settlement body, that consent becomes the basis for the binding nature of the decision. So by becoming a party to the convention, a state consents to the jurisdiction of at least one dispute settlement body under Article 287, and this body is then authorized to make binding decisions. Compliance. UNCLOS does not contain tools for enforcement. So this raises the question of compliance. Here I'd like to introduce two aspects of compliance. The first is the following. How do we know a state complies with the ruling? Measuring compliance with the ruling is less straightforward than it appears at first glance. It requires three things: identifying what the judgment demands, assessing whether the facts on the ground satisfy these demands, and determining how much compliance is enough. So let's briefly look at the awards and look for instances of compliance or non-compliance. So this is not a comprehensive analysis. We'll discuss that in more detail in the next panel. The arbitral tribunal made three broad findings. First, it ruled that China's maritime claims within the 9-dash line were incompatible with UNCLOS where they exceed the normal limits set by the convention. Any historic rights had been extinguished if ever they existed. It also found that China cannot enclose the Spratly Islands with straight baselines or treat them collectively as a unit for EEZ and continental shelf purposes. Second, the tribunal concluded that none of the features of the Spratly Islands or Scarborough Shoal qualify as islands capable of generating an EEZ or continental shelf. Accordingly, China is entitled only to an EEZ on continental shelf from its mainland and territorial seas around high tide features in the Spratlys and Scarborough Shoal. And then there are a number of points about Chinese activities that violate UNCLOS, including like a fishing ban, destructive giant clam harvesting, and preventing Filipino traditional fishing at Scarborough Shoal, and some others. It's also important to note what the tribunal did not say. The tribunal did not say that China must drop its claim to territorial sovereignty over high tide features. China can continue to claim sovereignty over these features, plus territorial seas around them. The tribunal was silent on these issues and would not have had jurisdiction. So if one now assesses China's conduct in light of this standard here of compliance, some instances of non-compliance with the award are obvious, like an annual fishing ban, where it interferes with Philippine EEZ rights, the continuous occupation of mischief reefs with its low tide elevation, blocking resupply missions to Second Thomas Shoal, again a low tide elevation China cannot claim, not allowing Filipino fishermen to fish at Scarborough Shoal. So this brings me to the second aspect of compliance, namely the process behind compliance. Here the observation is that decisions of international tribunals are often implemented through negotiated agreements. We can see this in cases such as the Arctic Sunrise case or the Chagos Islands cases and others. It's also not surprising that decisions of tribunals are often implemented through negotiated agreements, because there is no centralized enforcement tools or enforcement body in international law. So it's up to the parties to implement an award. Here, Russia, for instance, did not participate in the Arctic Sunrise case and rejected the tribunal's jurisdiction. Later, however, Russia quietly complied with the award and agreed on some compensation in negotiations. Moreover, the UK resisted Mauritius' attempts to gain recognition of its claims to the Chagos Islands for some time, and then it took an Annex 7 arbitration, an advisory opinion of the ICJ, and a decision of a special chamber of UNCLOS before the UK was willing to reach agreement with Mauritius on the status of islands. Now, looking at the Arctic Sunrise case and the Chagos Islands cases from a, let's say, optimistic angle, we can say a relatively smaller country can get a larger country to change its behavior through litigation, or in the case of the UK, through a whole series of litigation. A more pessimistic view, however, would insist that these cases in the South China Sea are not comparable. For Russia to comply with the Arctic Sunrise case was easy. It only needed to release a ship and its crew. So quiet compliance was not costly at all. And in the case of the UK and the Chagos Islands, we can say that the agreement reached between Mauritius and the UK allows to maintain a military base at Diego Garcia. So while compliance is costly, the negotiated agreement preserves the British strategic interest and the US strategic interest. So this short points raise the following question. What could compliance with the South China Sea arbitration look like? In particular, and here in particular regarding features China can claim in the territorial seas around them. And how can one get there? Some steps may have already been taken in recent years. So it is possible to identify some important and far-reaching consequences of the award for negotiations between China and the Philippines. The award already affects diplomacy, negotiations, and coalition building in the disputes. For example, the award represents de facto a minimum demand in negotiations between China and the Philippines. So far, I cannot see that the Philippines or any other Southeast Asian country is willing to agree on an agreement with China that would be inconsistent with the South China Sea arbitration. So this is the sense of the award de facto established a minimum demand for negotiations. We can also see a certain convergence of the legal positions of Southeast Asian claimants. So the Philippines, Malaysia, Vietnam, Indonesia all take the South China Sea arbitration as the common reference points for their claims. We can see this in the note verbal, all these states sent to the UN in the context of Malaysia's submission for an extended continental shelf. And here, interestingly, Malaysia and Vietnam, for instance, they do not mention the arbitral award in their note verbal. But they do something which is much more important than mentioning the award. They adopt the essential findings, essential rulings of the award as their own position. So what the award decided is now, in essential parts, the position of Malaysia, Vietnam, Philippines, and Vietnam. So here we have a convergence of legal positions. And we have one document, one shared document with very high authority that clarifies the extent of the legal claims in the South China Sea. So here, that is a very important development. So what is important to take away from this slide is that there is an inherent tension between the standard for compliance, so the question how much compliance is enough, how could compliance look like, and the observation that often compliance, the process behind compliance is a negotiated agreement. Many thanks, but before we come to your question, let me recapitulate what we have discussed. We started with consent. A state consents to the entire dispute settlement system by becoming a party to the Law of the Sea Convention. No reservations are permitted. The dispute settlement system combines two approaches, voluntary procedures and compulsory procedures. Voluntary procedures consist of negotiation, conciliation, but also arbitration and adjudication. Where states agree to bring a case to arbitration, this is a voluntary use of arbitration. The relationship between voluntary and compulsory procedures is the following, where a dispute could not be settled following voluntary procedures, compulsory procedures are available. Courts and maybe we should say another point, whereas all types of disputes can be brought to voluntary procedures, compulsory arbitration is subject to exceptions, including military activities and boundary delimitation, but courts and tribunals have adopted a narrow interpretations of these exceptions in recent cases. They did not see something like implied exceptions to their jurisdiction. Consent to the entire dispute settlement system is also the source for the binding character of decisions or tribunals. Now with that, I conclude my presentation. And if you want to read more, perhaps I'd like to promote my book. You can read my book, Ocean Governance and Conflict in the East and South China Sea. And if you're interested in more details about the South China Sea arbitration and its impact on the dispute, here are some recent articles. Beyond Compliance, the impact of the international arbitration on South China Sea disputes, or another one in the Heidelberg Journal of International Law, and one more, let's say, doctrinal analysis of the jurisdictional separability between questions of entitlement and delimitation in the Asian Journal of International Law. So many thanks, and I look forward to your questions.
Thank you so much, Dr. Christian Schultheis. Now the floor is open for the question and answer.
Okay, I can see already, there are already a number of questions. Perhaps I will always take 2 or 3, and then we see. I saw you first, Mr. Sape.
Thank you very much for your presentation. And as a Filipino, we acknowledge and your recognition of our national hero, Dr. Jose Rizal. Despite that you cannot bring us flowers here, your presentation here is already a flower by itself. Okay, proceeding. The same with other international cases decided upon by international courts and tribunals. Any disagreements or dissenting opinions actually do not change the decision of cases decided already. And despite that, the arbitral tribunal in the South China Sea case declares already that the award is final and binding, such disagreements can just be influential in future cases. I'd like to hear your counter argument. In this argument that pertaining to Article 281 and Article 282 of UNCLOS. So Article 281 of the UNCLOS clarified that both states parties should first have agreed to seek settlement of a dispute before utilizing Article 9 of Annex 7 to justify the continuity of the proceedings. Article 282 provides that states parties must have an agreement that such disputes shall be submitted to a procedure entailing a binding decision. Therefore, Article 9 of Annex 7 can only be used if both states parties have agreed and satisfied the requisites as provided for in both Articles 281 and 282, respectively.
Okay. And Ms. Faller?
Good morning. Thank you for that lecture. It was very interesting to hear more a thorough and in-depth discussion on dispute resolution. My name is Solja Harris Falier, and I am a faculty member of the Department of International Studies from Far Eastern University. I'd like to ask a question is that, to what extent can subsidiarity genuinely reconcile the tension between bilateralism and compulsory dispute settlement under the United Nations Convention on the Law of the Sea, given that states may invoke bilateral negotiations strategically to probably resist adjudication, as seen in the South China Sea arbitration? And my second question is that, given that both ICJ jurisdiction and compliance depend on state consent, does the South China Sea experience suggest that international law is ultimately limited to shaping norms rather than settling disputes where major powers refuse to engage? Thank you.
All right. Let's take the questions. Can we go back to the slides, if possible? Can we see the slides again? Yeah, here we go. Wonderful. So, where are we? No, that's the wrong direction. Yes, okay. Here we go. So the question was, can Annex 7 arbitration only proceed after procedures following Article 281 and 282 are exhausted or have been tried? Now, when it comes to Article 281, like voluntary procedures, here we go. So what is the essence of this? So the basic argument is, yes, first voluntary procedures, then compulsory procedures. But now the more specific question is when, let's say, it's three questions. One is kind of when are voluntary procedures exhausted? Right? What does exhaustion mean? And more specifically, when is Article 281 relevant, and when is Article 282 relevant? Now here the key thing is, so in Article 281, the question is, can it exclude recourse to compulsory proceedings? And the answer is yes, in principle it can. But as between China and the Philippines, it cannot, or it did not, because there is no agreement that does exclude any further procedure. China made the argument and said the Declaration on Conduct is such an agreement that excludes any further procedure. The Philippines said no, and the argument was accepted by the tribunal for two reasons. Number one, the DOC is not binding, so it's not an agreement. And number two, it does not explicitly exclude any further procedure. So here we can add that the decision of the South China Sea arbitration is different from the southern bluefin tuna cases, where a tribunal was satisfied with much less. Like there was an agreement, and it kind of inferred from it that there is an agreement to exclude compulsory procedures under Section 2. This was strongly criticized later by lawyers, and the South China Sea arbitration did not follow this and said, let's say had make a test of two criteria. It needs to be a binding agreement, and it has to exclude further procedures explicitly. Oh, Article 282, you also ask about this, how to read this. So, if the state parties have agreed to submit a dispute to a procedure that entails a binding decision, that procedure shall apply in lieu of the procedure provided for in this part. Does this mean states to a dispute have first to go through any kind of binding procedure that they have agreed on, and only then they can go to Section 2 procedures? Of course not. If there is no such procedure available, as between China and the Philippines, there is no such procedure available. If there was one, then you could say Article 282 makes sure that they first need to try, or first have to go through this procedure. So it then takes precedence. So an example would be an optional clause under Article 36, paragraph 2 of the ICJ. So between two states that trigger this optional clause, then this would take precedence over Section 2. And now the next question of Ms. Faller was about can states invoke bilateral negotiations strategically to exclude compulsory dispute settlement? They try, but ultimately they cannot. Now here the question is how much negotiations need to have occurred before a state can bring a dispute to binding procedures. Sometimes you read negotiations need to be exhausted. The ICJ did not accept this in, what was it, which case was it, land boundary dispute, land and maritime boundary dispute, Cameroon v. Nigeria. I guess the broader issue is kind of how much negotiations need to have taken place before a dispute can go to compulsory procedures. There's some negotiations you can say need to have taken place, but how much is needs to be decided on a case-by-case basis. I think in the Arctic Sunrise case, the Netherlands quite early on signaled their intention. They will bring the case to a tribunal, and Russia later criticized it, saying, well, negotiations were not exhausted, but the tribunal did not accept this. So some amount of negotiations need to have taken place, but it's not necessarily that all diplomatic negotiations are exhausted. So it's not possible once the state has the idea another one may bring a dispute to arbitration, and then suddenly starts, well, let's have intensive negotiations and so on, to use this strategically. This, I think, would stretch stretch the idea of the voluntary procedures. Okay, let's continue. There's one question. There's 1, 3. Okay. I don't know in which order. Maybe I start with Mr. Moller, and then we go Mr. Lopez or Daniel. Okay.
Good morning, Dr. Schultheis. I'm Oliver Moller from MN Law and IBP Cebu City. My question is, in your opinion, what are the jurisdictional, practical, and strategic limitations that the Philippines may face should it decide to initiate a second compulsory arbitration against China, both for its both for acts after the 2016 arbitral award and for its continued refusal to abide by the same award.
Okay. Mr. Lopez?
Thank you very much, Professor. It was indeed a very interesting and informative lecture. My question is on the perspective of a layman, like a layman myself. I'm not a lawyer. My question is, if a legally binding ruling, such as the South China Sea arbitration under UNCLOS, is simply ignored by a superpower or rejected by superpower, what does it say of the effectiveness of the dispute settlement under UNCLOS? And as to the measurement of success, how do we measure it? If not by actual compliance, then how then can we measure the success of the ruling? Thank you very much, Professor.
Mr. O'Daniel?
Thank you. The Chinese embassy in Manila constantly posts on social media about the arbitral award. And so let me just quote one post from the Facebook page of the embassy. It says that the International Arbitral Tribunal in question was nothing but an ad hoc tribunal and has nothing to do with permanent international judicial bodies such as the International Court of Justice or the International Tribunal on the Law of the Sea. So there seems to be a consistent effort from China to portray the decision of the Annex 7 Arbitral Tribunal as carrying less weight compared to permanent bodies like the International Court of Justice. Can you clarify? I think this is very important for all of us here to fight this information. Can you clarify once and for all this issue in terms of being binding and their validity? Do Annex 7 Arbitral Tribunal decisions carry less weight compared to permanent bodies like the ICJ and UNCLOS? Thank you.
All right. Thank you very much. Perhaps I start with a question from Mr. Lopez. So if ignored, what is the effectiveness of decisions or arbitration? Now, you can take several perspectives. One is, of course, compliance is a key thing, right? At least from a legal perspective, a decision is final and binding, so you expect compliance. But I would say it's not the only thing. As I very briefly indicated towards the end of my presentation, there are other consequences an arbitral tribunal can have, and these consequences matter a great deal. Right? So if there is a convergence of the legal positions of Southeast Asian claimants, if they all agree that what are the limits of claims in the South China Sea, it is very important for their negotiations with China. So here the broader perspective one can take is, in a contentious case such as the South China Sea arbitration, compliance was not very likely from the beginning. It was always to be expected there will be a process of struggle where one needs to work based on the legal decision to implement it. So implementation does not come by itself. It needs to be done. It has to be, it's a result of work. Right? And that takes place over many years. So delay here is not the exception, but delay is a kind of a natural, let's say, result of the fact that the decision is so contentious. So here the effectiveness, I would say, if we ask the question of effectiveness, to not only look for compliance, we should also look for other effects, such as how does the tribunal's decision affect negotiations between Philippines and China? How does it affect interactions in the South China Sea as a whole? How does it affect the positions of Malaysia and Vietnam? How does it affect the support non-regional states offer to the region? And I would say all of this, we can say all of this was changed by the arbitral award. So this is effective, right? So these are effects, these are impacts, consequences, and they are real in the real world. They are powerful, but it's not compliance. So to go through compliance, We need much more time, as we can see. And here, the last point in the presentation was as well, there's a certain tension between what is compliance and how to get there through a negotiated agreement. Right? You cannot, I would not expect to wake up one morning and read in the news, China declares we comply with the award. I mean, if you expect this, I think you are making a mistake. Right? So the expectation needs to be what steps could be undertaken towards implementing the award through regional diplomacy, through bilateral diplomacy between the Philippines and China, and as well by kind of aligning international support for these diplomatic efforts. I think this is the perspective I would take. Yes, Mr. O'Daniel. So the arbitral award has nothing to do with the ICJ and UNCLOS. In a way, this is not completely wrong because it's an Annex 7 arbitration, right? It's established under the law of the Sea Convention. It is not a decision by the ICJ. It's not a decision by UNCLOS. But this does not mean it has less weight. It does not mean it is not binding or is less valid. The validity and bindingness comes from the procedures defined in the law of the Sea Convention. And the starting point, remember the starting point of the presentation was consent. A party that ratifies the law of the Sea Convention consents to the dispute settlement system in its entirety. This consent is also the source for the binding nature of awards. This consent is the source for the validity of it. So the validity and binding nature of it is exactly the same as the validity and binding nature of decisions by UNCLOS or the ICJ. And we can also see that in the procedural details. Right? As I said, the decision is final, it's binding. Which case was this? Let me just go back. I think here we have it. Here, I like to quote that, read that quote again of the ICJ in the application of the Genocide Convention case 2007. And decisions of courts, and it's also applied to arbitral tribunals, are final in the sense that they cannot be reopened by the parties as regards the issues that have been determined. This applies as well to Annex 7 arbitration. What was Mr. Mora, what are the limitations for a potential second case? Well, this is of course a very big question. Maybe we can discuss it in the panel in more detail. Perhaps I could just offer some thought. It's not comprehensive. Now, first point to mention is, if we take a comparison, sometimes it's used, like the UK and the Chagos Islands cases, right? They had a whole series of litigation. Arbitration, UNCLOS, and advisory opinion of the ICJ, right? So 3 different bodies. So a whole series of litigation. And as we can see, this was necessary to get the UK to accept a decision. So you might say, okay, sometimes the series of litigation is what is necessary. Now, if you look into the details, a bit more into details, then the question would be, what kind of could a second case add to the first case, right? What specific things could you identify where China violates the law of the sea? These have not yet been clarified by the arbitral award. Well, this is one question I would ask, right? What could the second case add to a first one? Then there is a question, do you want to seek confirmation for what is already decided in the first case? If you say this is useful, the question would be, why? Right? Why do you need confirmation? The Annex 7 arbitral award is final and binding. It's there. It cannot be changed. Right? And the issues cannot be reopened. Why do you need confirmation? Right? So that would be the second question. And the third point is, that goes back to the question Mr. Lopez asked on the effectiveness. What effects or consequences do you expect that a second case could have when it comes to regional diplomacy negotiations between the parties? Right? Do you have the expectation that bringing another case would add to, let's say, would add to the leverage the Philippines has gained through the first case? So these are some of the issues. But I can see I must come to an end, so I thank you all for your questions. Thank you very much.
Let's give a round of applause to Dr. Schultes. Thank you very much, sir. At this point, ladies and gentlemen, or by the way, you may reserve your questions because Dr. Schultes will be back after the break to join the next panel, so you may reserve your questions. Let's have an 8-minute break, so let's be back before 10:15 for us to start the public panel 1. So you may grab your coffee outside. Thank you very much.